24 seconds. That's how long the actual signing took, according to courtroom footage. 24 seconds to do something no federal judge has ever done to a sitting president in the history of this country. Nobody predicted this. Not legal analysts, not constitutional scholars, not Trump's own legal team who were sitting in the courtroom when it happened. They expected a contempt finding. They expected fines. They expected another round of legal back and forth that could stretch out for weeks. What they got was something entirely different. What they got was a federal judge saying, I'm not going to fine you. I'm not going to warn you again. I'm going to take away your ability to operate. Within 11 minutes, the White House press office issued a statement calling the ruling unconstitutional overreach. Within 14 minutes, Senate leadership called an emergency session. Within 19 minutes, the ruling was trending on every single social media platform globally. 19 minutes for the entire world to find out that a federal judge just did something unprecedented to a sitting president. This is not a political story. This is not a debate with two sides. This is a federal court stripping operational authority from the executive branch of the United States in real time. And what happened next made it 10 times worse. 2 days ago, this was a subpoena dispute. Standard legal process. The kind of thing that gets resolved quietly in federal courts every single week. Judge Katherine Morales issued a subpoena for White House communications records related to an ongoing federal investigation into alleged misuse of executive authority. Routine discovery request. Nothing unusual about it. Wednesday, 9:15 a.m. Subpoena delivered to White House counsel's office. Deadline for compliance was Thursday at 5 p.m., 32 hours to produce documents. That's a tight window, but not unreasonable for records the White House should have immediate access to. Wednesday, 4:47 p.m. White House counsel responded, not with documents, not with a negotiation, not with a request for extension, but with a blanket refusal citing executive privilege over all requested materials, every single document. No partial compliance, no discussion, complete defiance. Thursday, 9 a.m. Judge Morales issued a compliance order in direct language. Produce the documents by 5 p.m. today or face contempt proceedings. She gave them 8 more hours. She was being generous. Thursday, 5 p.m. Deadline passed. Nothing produced. No response from White House counsel. No emergency filing. No communication with the court whatsoever. Complete silence. Thursday, 5:38 p.m. Judge Morales filed contempt findings 38 minutes after the deadline. She was ready. She had the paperwork prepared. She anticipated the defiance before it happened. Before Wednesday, this was a legal question that could have been resolved with a phone call between attorneys. After Thursday, it was a direct confrontation between a federal judge and a president who refused to acknowledge her authority. Each missed deadline built the legal foundation. Each act of defiance gave Judge Morales more justification. By Thursday night, she had everything she needed. Friday morning, she used it. This is where most coverage gets it wrong. They say the judge stripped privileges and then move on to political reaction. They don't explain what that actually means in practice, what it means operationally, what changed the moment that signature hit paper. Here's what Judge Morales' order specifically targeted. First, executive communication authority. The president's ability to issue binding directives to federal agencies through executive memoranda was suspended pending compliance with the court's subpoena. That means directives sent from the White House to federal agencies after 10:22 a.m. Friday carry no legal force. Agencies don't have to follow them. They're paper. Trump's team apparently thought they could just keep saying executive privilege and the grown-ups would eventually get tired and go away. The court responded by making those privileges meaningless. Second, classified briefing access was restricted, not eliminated entirely, but restricted to national security emergencies only as determined by the Director of National Intelligence, not by the President, not by the White House Chief of Staff, but by the DNI independently. The President lost control over his own intelligence briefings. The man who spent years attacking the intelligence community now has to hope someone else decides he needs to see the information. Third, executive privilege claims were frozen. Any pending or future claims of executive privilege in federal court proceedings were suspended until compliance with the original subpoena. That one is devastating. It means Trump cannot use executive privilege as a shield in any active federal case until he hands over those documents. Every legal strategy his team is running in every courtroom in the country just lost its primary defense tool. Before this ruling, executive privilege was the foundation of presidential legal strategy. After this ruling, it doesn't exist for Trump until he complies. No federal judge has ever restricted a sitting president's operational authority as a consequence of defying a court order. Courts have issued fines. Courts have issued contempt findings. Courts have ordered compliance. But no court has ever said, because you won't comply, I'm taking away your ability to function as president. That's what makes this different from everything that came before. This isn't punishment. This is operational restriction. Judge Morales didn't fine him, she disabled him. The entire ruling runs 47 pages. Dense legal reasoning, constitutional precedent citations going back to Marbury v. Madison in 1803. But the whole thing turns on 5 words buried on page 31. Operational authority contingent on compliance. 5 words. That's the mechanism. That's what makes this enforceable. That's what separates this from every other court ruling against a sitting president. Judge Morales didn't argue that presidents must obey courts. That argument has been made before, and presidents have ignored it. She argued something completely different. She argued that presidential operational authority is not automatic. It is contingent. It depends on the president operating within the constitutional framework, and defying federal court orders places the president outside that framework. The reasoning goes like this. The Constitution grants the president executive authority. But that authority exists within a system of checks and balances. Courts are part of that system. When a president defies a court order, he is not exercising executive authority. He is operating outside the constitutional structure that gives him that authority in the first place. Therefore, the court has the power to restrict operational privileges until the president returns to compliance with the constitutional system. Constitutional scholars are calling this the most carefully constructed judicial order against a president ever written. And here's why. Judge Morales anticipated every single appeal argument before Trump's team could make them. Executive immunity addressed on page 12. Separation of powers objection addressed on page 19. Political question doctrine addressed and rejected on page 24. Emergency presidential authority exception addressed on page 34 with the national security carve-out already built in. She didn't leave gaps. She closed every loophole before Trump's lawyers could find them. Every emergency filing they've submitted since Friday morning has been rejected because Judge Morales already answered the argument in the original ruling. She spent weeks writing this. She knew exactly what was coming and she built the order to withstand it. 10:22 a.m. The ruling dropped. By 10:33 a.m., Trump's lead attorney was on the courthouse steps telling reporters the ruling would be overturned within hours. His exact words, within hours. That was Friday morning. It's still standing. 10:36 a.m. White House press secretary issued a written statement calling the ruling a radical act of judicial tyranny. 4 minutes later at 10:40 a.m., a second statement was issued contradicting the first. The first statement said the ruling was unenforceable. The second statement said the legal team was filing an emergency appeal to overturn it. You can't call something unenforceable and simultaneously file an emergency appeal to stop it. That contradiction told you everything about what was happening inside that building. Panic. 11:15 a.m., Trump's legal team filed their first emergency stay request. Rejected by 11:47 a.m. 32 minutes. They filed a second emergency motion at 12:30 p.m., rejected by 12:31 p.m., a third at 1:15 p.m., rejected by 1:44 p.m. 3 emergency filings in 3 hours, all rejected, each one recycling arguments Judge Morales had already addressed in the original 47-page ruling. They were throwing paper at a wall and nothing was sticking. Now watch who disappeared. Senator Richardson was defending Trump on cable news Thursday night, calling the subpoena politically motivated. Friday morning after the ruling, he canceled all media appearances. No statement, no explanation, gone. Representative Collins tweeted support for the president at 9:58 a.m. Friday, 24 minutes before the ruling, never tweeted again that day. His office stopped answering press calls by noon. By 3 p.m. Friday, not a single Republican member of Congress had publicly defended the president's position on the ruling itself. Not the subpoena, not the politics, the ruling. Nobody would touch it. The allies didn't just go quiet, they evaporated one by one between 10:22 a.m. and 3 p.m. Every public defender of presidential defiance vanished from the conversation entirely. This is where you need to see the full picture, because what's happening right now isn't one story. It's three stories running at the same time, and they're feeding into each other. Track one, judicial enforcement. Judge Morales didn't just sign the order and walk away. She established a compliance monitoring mechanism. A special master appointed by the court is now reviewing all executive communications leaving the White House to verify the operational restrictions are being followed. Every directive, every memorandum, every executive order, all of it flows through a court-appointed monitor before it reaches federal agencies. If the White House issues a directive that violates the restrictions, the special master flags it and it becomes void. The court isn't trusting the president to comply. The court is verifying compliance in real time. That has never happened to a sitting president. Track two, congressional response. House Judiciary Committee announced an emergency hearing for Monday morning. Not an investigation, not a preliminary review, a formal hearing on whether Trump's defiance of the subpoena and subsequent loss of operational authority constitutes grounds for accelerated impeachment proceedings. Speaker's office confirmed Saturday evening session to discuss timeline. Before Friday, impeachment was a slow-moving background conversation that nobody expected to go anywhere for months. After Friday, it's on the Monday calendar with witnesses already being called. Track three, executive branch internal crisis. This is the one nobody is covering. Cabinet members and federal agency heads are now operating under a federal court order that says presidential directives issued after 10:22 a.m. Friday carry no legal force unless cleared by the special master. That puts every cabinet secretary in an impossible position. Do they follow directives from the president who appointed them, or do they follow the court order that says those directives aren't valid? Defense Secretary Williams issued a statement Friday afternoon saying the department will follow all lawful orders. That word lawful is doing enormous work in that sentence. He didn't say presidential orders. He said lawful orders. That's a cabinet member publicly hedging on whether to obey the president. If track one enforcement holds through the weekend, then track two, impeachment accelerates Monday because Congress sees a president who can't function. If track two moves fast with impeachment proceedings, then track three cabinet crisis deepens because agency heads start calculating whether to distance themselves from a president facing removal. If track three breaks first with cabinet members publicly refusing directives, then tracks one and two both accelerate because judicial enforcement is validated and Congress sees institutional collapse. They're synchronized. Movement on any one track forces movement on the other two within hours. Here's the question every constitutional scholar is asking right now, and nobody wants to answer publicly. Can a federal judge actually do this? Can a single federal judge strip operational authority from a sitting president of the United States? The honest answer is nobody knows. It has never been tested. It has never been litigated. It has never happened before. Friday at 10:22 a.m., the argument for why this is valid goes like this. The Constitution establishes three co-equal branches of government. Co-equal, not one above the others. When the president defies a federal court order, he breaks the system that gives him power in the first place. Judge Morales argued that operational authority is not a birthright of the presidency. It flows from the constitutional framework. Step outside that framework by defying courts, and the authority can be restricted until you step back inside. Legal scholars at Harvard and Yale have called this reasoning airtight, unprecedented but airtight. The argument against says this is the most dangerous judicial overreach in American history. One unelected judge decided to functionally disable the executive branch. The president was elected by millions of voters. Judge Morales was appointed. She answers to nobody. If one judge can strip a president's authority today, what stops another judge from doing it tomorrow over a different disagreement? Where does it end? Who decides which court orders trigger privilege stripping and which ones don't? Concrete example. You run a company. A court orders you to produce financial documents. You refuse. The court doesn't fine you. Instead, the court says you can no longer sign contracts, approve payroll, or make business decisions until you comply. Your company still exists. You're still the CEO, but you can't do anything. That's what happened to the presidency on Friday morning. The office exists. The man holding it can't operate it. Whether that's constitutional genius or constitutional destruction depends on what happens next. The power map shifted 3 times in 3 days. Here's where every key player stands right now and what they're doing about it. President Trump's position is sitting president with active court order restricting his operational authority. His strategy is filing emergency appeals continuously while publicly claiming the ruling is unconstitutional and unenforceable. His power on paper is still commander-in-chief. In practice, every directive he issues goes through a court-appointed special master before it reaches anyone. He controls the office. He cannot operate it freely. His team is burning through legal options at a rate that suggests they don't have a long-term strategy. They're reacting hour by hour. Judge Katherine Morales' position is federal judge who issued the most consequential ruling against a sitting president in American history. Her strategy is methodical and preemptive. She anticipated every appeal argument and closed every loophole in a 47-page ruling she spent weeks preparing. Her power is she controls the compliance mechanism through the special master, and she controls the timeline for restoring privileges. The president gets his authority back when she says he gets it back, not before. Congressional leadership's position is divided and scrambling. House Judiciary Committee has Monday hearings scheduled. Speaker is calling Saturday emergency session. Their strategy is trying to figure out whether to accelerate impeachment or wait for courts to resolve the crisis. Their power is they hold impeachment authority, which is the one mechanism that could override everything else happening right now. Attorney General Davis's position is sitting between the president who appointed him and a federal court order he's legally obligated to follow. His strategy is silence. He has not issued a public statement since the ruling. No press conference, no written response, nothing. That silence is deafening because the Attorney General is the top law enforcement officer in the country, and he's saying nothing about the most significant law enforcement moment in presidential history. Federal Marshal's position is standing by, awaiting instructions from the court if enforcement escalates beyond the special master mechanism. Their director issued one statement Friday afternoon: "We execute lawful court orders." 5 words, no elaboration. Joint Chiefs of Staff position is formally distancing from the crisis. Public statement says military remains outside political and legal disputes. That's important because they're telling everyone they won't intervene on either side. Who stepped forward? Judge Morales. Chief Justice Roberts, who declined to issue an emergency stay of her ruling Friday afternoon. The special master who accepted the appointment within 2 hours, who went silent. The Attorney General, Senate Republican leadership, every Trump ally who was publicly defending him 48 hours ago. The silence tells you where institutional loyalty is landing. Not with the president, not with the court, nowhere. The institutions are frozen, waiting to see who wins before they pick a side. That's the most dangerous part of this entire crisis. The people who are supposed to hold the system together are standing on the sidelines watching. Everything converges this weekend. Here's the exact timeline of what's coming and when it hits. Saturday morning, 9 a.m., House Speaker convenes emergency leadership session. Both parties. This is where Congress decides whether Monday's Judiciary Committee hearing is a discussion or the beginning of formal impeachment acceleration. Watch the language in the statement that comes out of this meeting. If they say reviewing the situation, it means they're waiting. If they say taking action, it means impeachment is moving. Saturday afternoon, Trump's legal team is expected to file their 4th emergency appeal. This one goes directly to the Supreme Court. They'll argue Judge Morales exceeded her constitutional authority. Likely outcome, based on the pattern so far, is rejection. Chief Justice Roberts already declined to stay the ruling Friday afternoon. Filing again doesn't change the legal landscape. It burns another option. Sunday midnight compliance deadline. Judge Morales gave Trump 72 hours from Friday 10:22 a.m. to produce the subpoenaed documents. If documents are produced, the special master mechanism stays in place, but operational restrictions begin lifting within 24 hours. If documents are not produced, enforcement escalates Monday morning. Monday, 9 a.m., House Judiciary Committee hearing. Witnesses are already confirmed. Constitutional law experts testifying on whether operational privilege stripping constitutes grounds for impeachment proceedings. 3 possible outcomes from here. Outcome 1, Trump complies before Sunday midnight. Documents are produced. Special master verifies compliance. Operational restrictions begin lifting Monday. Crisis de-escalates, but precedent is permanently established. A federal judge successfully restricted presidential authority, and the president blinked. That precedent lasts forever. Outcome 2, Trump refuses and courts escalate. No compliance by Sunday midnight. Judge Morales expands restrictions Monday morning. Federal marshals receive enforcement authorization. Congress accelerates impeachment timeline. Cabinet members face immediate decision on whether to follow restricted president or court orders. Constitutional crisis deepens significantly. Outcome 3, Trump partially complies. Some documents produced, others withheld under new privilege claims. This is the messiest scenario because it splits every track. Courts have to evaluate partial compliance. Congress has to decide if partial is enough. The special master has to determine which restrictions lift and which stay. Everything gets slower and more complicated. 5 things to watch that will tell you which direction this is heading before the news reports it. First, watch the Supreme Court response to Saturday's emergency filing. Speed of rejection tells you how settled this is. Second, watch which cabinet members issue public statements over the weekend. Silence means they're distancing. Statements of support mean they're choosing the president over the court. Third, watch whether Trump's social media tone shifts from defiant to negotiating. Language change signals compliance is coming. Fourth, watch whether congressional Republicans break silence with a unified statement that tells you whether the party has decided to defend or abandon. Fifth, watch the special master's first report Saturday evening. If White House communications are flowing normally through the monitor, it means quiet compliance is already happening behind the scenes, regardless of public statements. This isn't Washington drama that stays in Washington. When a constitutional crisis hits this level, it reaches everyone. We saw it already. Markets dropped 3.2% in 18 minutes after the ruling Friday morning. International investors started pulling positions from U.S. assets by Friday afternoon. The dollar weakened against every major currency before the trading day ended. That's not political noise. That's real money moving because real institutions lost confidence in the stability of the American system for the first time in decades. When that kind of uncertainty hits the economy, ordinary people feel it first. Grocery prices react to supply chain nervousness. Gas prices respond to market instability. Interest rates shift when institutional confidence wavers. Your mortgage, your car payment, your credit card rate, all of it connects back to whether markets believe the American government is stable and functional. Right now, they're not sure. And when markets aren't sure, people pay more for everything. That's why financial preparation matters more right now than it has in years. Building any kind of buffer between yourself and economic uncertainty isn't optional anymore. It's common sense. And here's something worth knowing about. Amazon is currently giving away $750 gift cards to eligible residents in the US, UK, Canada, and Australia. It's a straightforward promotion that's running right now. No hidden terms, no complicated process, just an opportunity to claim $750 in Amazon credit that you can use on groceries, household essentials, or anything else you need to stock up on while the economic picture sorts itself out. In times like these, when prices are climbing and nobody knows what next week looks like, $750 in free purchasing power is not something you scroll past. It takes less than a minute to enter. Click the link on the channel page and see if you're eligible. Take care of yourself first. The political crisis will keep moving whether you're watching or not. If you're following this story and want to stay updated on every new development as this constitutional crisis unfolds, make sure you subscribe to the channel and turn on the notification bell right now. We're tracking this in real time and we'll bring you the next update as soon as it breaks. Drop your thoughts in the comments below. Do you think Trump will comply by Sunday midnight, or is this heading towards something much bigger? Like this video if you want more breakdowns like this, and share it with anyone who needs to understand what's really happening. Thank you for watching. Stay with us on this channel for the latest development.